Hey everyone, I am doing a video today on a case study because I had a consultation this morning with a prospective client, and it was an unfortunate consultation. Several things kind of went wrong, so I thought it would be a good idea to talk about it. So this family came to me because their teenage child was involved in a car accident, and while they do have car insurance, they are potentially going to get sued. It's in the very early stages, and the other parties are making inquiries as to their assets. So they came to me looking for a trust or a way to protect their assets. Problem number one, they came to me after the accident already happened. It's too late to do asset protection after something happens. There's something called the Fraudulent Transfer Act in Florida and probably many other states, which prevents you from transferring your assets after you have creditors or after you even anticipate having a creditor. So too late. The time to do asset protection is well before a creditor ever exists. So that was the first problem. The second problem, they thought they were going to put some assets into a revocable trust, which is a very common trust that a lot of people do. Most of our clients have them. We do revocable trusts for estate planning purposes, for probate avoidance, for protection of your kids, for things like that. Revocable trusts do not provide any asset protection whatsoever for yourself, for the person putting the assets in the trust, for the grantor or the settlor. Zero, zilch, none. Irrevocable trust with an I might provide some creditor protection. However, you can't use trusts in Florida to protect your assets from your own creditors. We are not a very good asset protection type of state. There are other states where you can go to do these. They call them DAPs, Domestic Asset Protection Trusts. Nevada probably tops the list of best protections. So that's where you want to go to use one of those trusts. But they are not what people think. You're going to give up significant control over your assets. You can't just plop your assets into a trust and say, oh, see you later, creditors. It doesn't work like that. So a lot of people don't understand that. They come in looking for that, and it's probably really not what they want. What else did they do wrong? They have a young driver. So things that they were unaware of. One, the car is titled in one parent's name. The other parent signed for the permit when the child got their license. So a lot of people probably don't realize this. When your child gets their permit and one of the parents has to commit to being financially responsible for that child until they turn 18, pick the spouse with the least amount of assets or income to give you some sort of planning opportunities. Now, both parents are probably going to get sued. It's not 100% to be able to restructure, the title of your properties and your cars and all that stuff, but do the best you can. At least give it some thought when your child is going to get their permit. And only one parent has to sign, so pick the parent with the least assets, the least income. Don't title the cars in both spouses' names. It's very easy to transfer a car title if somebody dies. Keep it in one spouse's name to potentially reduce your liability. They have some other assets that they could have protected if they put them in an LLC. Now, LLCs are not bulletproof. It's not that you plop your assets in an LLC and nobody can ever do anything. And that's a much longer video, but they do provide some creditor protection and some barriers to creditors getting at your assets. So that is something that you can use specifically for rental real estate. Definitely commercial real estate should be in LLCs, but even residential real estate can benefit greatly from being in an LLC. The last place where they went terribly wrong was their car insurance limits. And I'm not an insurance expert. However, I know that I should have more than $10,000 of bodily injury protection on my car insurance. You must look at your car insurance limits, especially if you have young drivers in your house. 10, 20 bodily injury is absolutely not sufficient. Bodily injury covers other people that you hurt, people in your car, people outside of your car. It doesn't cover you, the driver, it covers the other people. This is where you're going to get sued, not for property damage, not for, the damage on the car. You don't have to worry about yourself necessarily, but you got to worry about the other people who are going to sue you. Make sure you have adequate liability coverage. Something that goes hand in hand in that is called uninsured or underinsured motorist coverage. This is coverage for you when the other driver doesn't have enough coverage or any coverage at all, which is very common in South Florida, where people are driving out there and they have no car insurance at all. If that happens, if you were in this accident and the other driver only had $10,000 of bodily injury coverage, you could collect under your own policy if you had under/uninsured motorist coverage. It's not cheap, it's kind of expensive, but it's super important. So please go out today and check your car insurance coverage. And of course, you could always get an umbrella policy, which is just extra coverage on top of everything. Feel free to give us a call if you have any questions about this video.